All right, good afternoon, everybody, and welcome to a PilieroMazza annual review. Today's webinar is what DOJ's annual FCA report means for government contractors. I am Matt Feinberg. I'm the chair of the Litigation and Dispute Resolution Practice Group and co-chair with my co-presenter today of PilieroMazza's False Claims Act and Audits and Investigations team. I'll give Jackie a little bit of a second to introduce herself, and then we'll get started.
Sure. Thanks, Matt. Good afternoon, everyone. I'm glad to be here today, able to talk to you guys. As Matt mentioned, I'm a partner in our government contracts group. In our group, we help both large and small contractors navigate all aspects of doing business with the government. One area I focus on is the helping clients deal with the False Claims Act issues that we'll be talking about here today, as well as counseling clients on other FAR and SBA regulatory compliance issues and bid protests, as well as just government disputes that they might be facing. So a little bit of background about me.
All right, so our very helpful marketing assistant is putting up a little bit of information about our firm. While you're taking a look at that, I do want to remind everybody that this webinar is for informational purposes only. Nothing we say is intended to be legal advice for your personal circumstances. If you do have follow-up questions or questions about your specific facts or circumstances, feel free to reach out to me or to Jackie after, or both of us, after the webinar. We'd be happy to talk about that. But the examples we're providing today and our commentary, it's not going to be applicable in every single situation. And so we are not creating an attorney-client relationship just based on the presentation of today's webinar. So getting started with a little bit of an overview of what we plan to talk about today. We're going to go, for those of you who've been with us before, this is, I think, the 4th year in a row or maybe 5th year in a row we've done a webinar on the annual DOJ statistics related to the FCA. We're going to go over very briefly what exactly is the False Claims Act, what we saw over fiscal year 2023, which ended at the end of September a few months ago, what we're expecting to see during fiscal year 2024 based on trends we saw in the report and based on our anecdotal experiences working with DOJ and defending companies that are accused of False Claims Act violations. And then at the end, we'll wrap up by talking about ways you can help protect your company, whether you are in the midst of an FCA defense or you might have an FCA matter come at you in the future. And from there, we'll start with a little bit about what is the False Claims Act.
Thanks, Matt. Here we go. Wanting to give a kind of short and sweet, we'll see how short and sweet I can make it, background on the False Claims Act. At a high level, the False Claims Act, or FCA, is a statute that imposes liability on any person who submits a claim to the federal government that they know or should know is false. It has the potential to impact all government contractors as well as commercial businesses that do business with government contractors. So, it has a really broad reach, and therefore it's critical for businesses to understand the FCA and how it works. It was first created in 1863. It was passed by Congress in response to defense contractor fraud that arose during the Civil War, at which time contractors sold the U.S. Army horses in bad health and faulty guns and ammunition, clearly creating problems. But since then, it's been significantly expanded and is used as the primary vehicle for the government to recover money that's been obtained or withheld by the government, from the government by contractors through misrepresentation. So as a brief primer, there are a number of elements that are required to establish liability under the FCA. First, there has to be a submission of a false claim. So a claim is a request for money or property, like an invoice or an obligation to pay the government. When we're talking about the claim being false, that means that the claim of entitlement to the funds was improper, incorrect, unlawful, or unjustified, or supported by misrepresentation. But not all incorrect or improper claims rise to the level of a violation of the FCA. Otherwise, that would basically mean that the FCA can create liability for breaches of contract where there are just inaccuracies in an invoice, which is not what the FCA was intended for. There are a few other elements that must be met. The false claim must be submitted with knowledge of its falsity. So knowledge in the FCA context means actual knowledge, reckless disregard for the truth or falsity of the claim, or deliberate indifference as to the truth or falsity of the claim. So it's important to understand that liability can arise here, not only where there's blatant and intentional fraud, but also where there's just reckless behavior, which is something similar to gross negligence, or deliberate indifference, which is basically where you're sticking your head in the sand like an ostrich, purposely ignoring the potential wrongdoing or red flags that pop up around you. So while there is an intent requirement under the FCA, the bar is not particularly high to establish that lowest level of reckless disregard. And then,
sorry, Jackie, before we move on with this slide, we're getting a couple of messages from the crowd that they can't hear us, or I'm not sure if you can hear us, maybe give us a comment in the comment section or send us a question just to confirm that we're able to be heard. If you can't hear us, I'm not sure how you would know to communicate with us, but if maybe you can hear us quietly or the sound is distorted, let us know. You may need to log out and log back in, but we've gotten a couple of notices now, so I'm a little worried that people can't hear us. But Jackie, sorry to interrupt. I guess go ahead and see if we can continue on.
okay. All right, and then the last element that needs to be met is the false statement has to be material to the government's decision to pay, meaning it has a natural tendency to influence the government in making that payment decision. So those elements of scienter or knowledge and materiality are pretty critical to differentiating between basic breaches of a government contract and FCA violations, which clearly are more serious. And then lastly, we want to note that there's a difference between civil and criminal false claims. Most of the time we see allegations of civil FCA violations, which result in the government seeking repayment of damages and penalties. But there's also the possibility for more egregious FCA violations, which usually involve intentional fraudulent conduct. The government can pursue that misconduct criminally against the company as well as the individuals that are involved. Can we go to the next slide?
Now I'm really worried that no one can hear us.
Okay.
Okay, there you go.
Okay, so types of FCA matters. FCA matters can take shape through two routes: government-initiated matters and qui tam matters. So government-initiated matters typically arise out of an audit or investigation, a complaint to a government whistleblower hotline, an agency office of the Inspector General, or the DOJ. So in these cases, the company or individual being investigated usually receives a subpoena or a civil investigative demand from a government agency. And if it proceeds to litigation, the US will be the plaintiff and will pursue the FCA violation and damages against the individual or the company. But the FCA also establishes a private right for individuals to file what's called a qui tam matter. So this type of case is brought on behalf of the US by a whistleblower who could be a former employee or perhaps a competitor or some other individual who might have inside knowledge of the defendant's actions and potential wrongdoing. So in this situation, the whistleblower, who's called a relator, files the qui tam suit under seal, so the defendant doesn't even know about the lawsuit right away. Instead, the government's given a chance to investigate the allegations and determine whether to intervene, and basically, if they do intervene, they would take over the case from the whistleblower. Eventually, the case would become unsealed and litigation could commence several years down the road. So it can take a long time for the government to go through that investigation process and make a decision whether to intervene. Once the seal is lifted and litigation proceeds, it plays out pretty much the same way as a government-initiated matter. But if the government declines to intervene in the case, for whatever reason, the relator can still proceed with it unless the government moves to dismiss it and is successful with that. One really critical point is that qui tam relators are entitled to between 15 and 30% of the total damages that are recovered by the federal government. So they're highly motivated to come forward with allegations and file that qui tam complaint. Can we go to the next slide? Okay, so next, relevant types of FCA violations. We just want to walk through some examples of different ways that you could end up facing liability under the FCA. The first is if there's presentment of a false claim for payment. So this is the most straightforward situation where the contractor submits a false invoice requesting money to which it's not entitled. So you can imagine this could occur where the contractor bills for services that weren't provided. For instance, if it bills for 500 hours when it was only providing 50 hours of work, or if it bills at higher rates than it was actually entitled to under the contract. So on its face, the invoice is incorrect. It's not reflecting the actual work paid or work performed or the rates that it was entitled to bill. The second type is where the contractor uses a false record or false statement in conjunction with a request for payment. So in these cases, the payment request or invoice itself may be accurate. So maybe you're actually billing for 40 hours of work and you actually perform that 40 hours of work, but the invoice is accompanied by some statement or record that's false, and it's that statement that induces the government to pay the claim. This often occurs when some certification is required. So there could be an express certification that influences payment, like a false certification that all contract requirements are met, or perhaps that all subcontractors have been fully paid when that's not actually the case. It will really depend on the language of the contract and the invoice as to what representations are actually required and being made. There can also be liability for implied rather than express certifications. So in this situation, the certification is not expressly required or made in the contract or on the face of the invoice itself, but it's deemed to be implied through the submission of the invoice. Basically, by submitting the invoice, you're impliedly certifying that you're in compliance with applicable laws and regulations and in compliance with the contract requirements. So if you think about like all of those FAR clauses that are included in your contracts, you know, when you're submitting an invoice, there's implied certification that you're in compliance with those requirements. There's also a duty to not knowingly withhold information that's material to the government's decision to pay. So being silent about non-compliance with material requirements can also lead to liability. Another basis for FCA liability is through the theory of fraudulent inducement. That occurs where the contractor induces the government to award a contract through false statements or fraudulent conduct. So an example here would be where a company misrepresents its small business or socioeconomic status, or perhaps where it makes material misrepresentations in its proposal, not intending to perform the way that it's proposed to perform. So in these situations, the government takes the position that all claims for payment that are submitted to the government under that contract are considered false because they're basically tainted by that initial misrepresentation that's used to obtain the contract in the first place. The third type of violation that we have here is the reverse false claim. So this is a situation where the contractor is already in possession of money or property that the government is entitled to, and it fails to return the money or property. This could occur when a contractor is aware that the government overpaid, but it fails to return that overpayment. And it also, this is a situation that we see with respect to the PPP program, which we'll comment on a little bit more later, where someone receives forgiveness for a PPP loan when they weren't entitled to it. Finally, there can be claims for conspiracy to violate the FCA. So conspiracy generally requires an agreement between two or more parties to commit an unlawful act by unlawful means, and there's at least one party commits an overt act in furtherance of the conspiracy. So allegations of a conspiracy could occur where a subcontractor is submitting false invoices to the prime contractor, who submits that invoice to the government. And it could also be a situation where a conspiracy between owners of two companies, they agree to team together and they falsely represent one company as a small business, but then have it pass through the majority of work and revenues to the other company. So it's basically like agreeing to use one party as a sham to get the contract as a small business, but then having the work performed by another company.
So before we move on to the next slide, we got an interesting question from the audience, and it's, are False Claims Act violations always related to a payment? And if we speak broadly, the answer to that is yes. I think it'd be more accurate to say it's always related to money in one form or another. So Jackie just talked a little bit about a reverse false claim. So that might come up in a circumstance where a contractor is in possession of money or property that belongs to the government and doesn't return it. That might be the circumstance where the government has paid certain amounts of money for contract performance, and then later on down the road, it determines that during an audit, for instance, that a subcontractor wasn't paid, but that was part of the invoice that the contractor submitted to the government. If that subcontractor wasn't paid, and there is no legal dispute as to the payment, then that might result in a reverse false claim argument from the government, because ultimately you can only charge the government on, let's say, a time and materials contract for work actually performed. Generally speaking, however, all False Claims Act violations are going to tie to money in some way. Otherwise, the government is unlikely to pursue it and unlikely to have suffered any damages. But that payment may take different types of forms. So one of the examples that Jackie gave was misrepresenting, say, hub zone status to obtain a contract. Ultimately, that contract may have been procured through the representation of hub zone status, or that the contractor is eligible to bid on a contract based on its hub zone status. It may not tie to a specific payment, but generally speaking, it is going to tie to money paid by the government or owed to the government in some respect. The other thing to think about in the terms of conspiracy is that False Claims Act violations travel up the chain. So if a second-tier subcontractor or a subcontractor or a vendor commits a False Claims Act violation, which the prime contractor ultimately submits to the government, then in theory, all of the parties in the chain would be liable under the FCA. This gets back a bit to the knowledge requirement under the FCA, and we'll talk about this a little bit later. I'll give you some specific examples. But generally speaking, a prime contractor may be responsible for the misrepresentations of its subcontractor if the contractor essentially had reason to know or the ability to investigate and learn the truth of whether a certification was false at the time it was made.
Yeah, so that really goes to, like, have you done your due diligence of your subcontractors? Are there any red flags that are apparent that you failed to follow up on or that you ignored? Have you gotten appropriate certifications from your subs? As long as there are no red flags, then you have a good argument that, you know, there's no knowledge there of those false claims that may come through your subcontractor. But it's very fact dependent on whether there can be liability to the prime for false claims that come from the sub. Great, moving on to FCA penalties. The FCA is an extremely powerful statute in large part because of the damages and penalties that can be imposed. So there's a mandatory damages component. Well, what we mean there is that the penalties may be imposed even where the government suffers no actual damages. The penalties currently are between $13,946 and $27,894 and that number is subject to further upward increases based on inflation. Usually we see about annual adjustments, but it can also be more often than that. Those are per violation, meaning the penalty amount can be imposed for every false claim that's submitted. So, even when there's no damages, you can be facing severe penalties if you are submitting a lot of invoices under a contract, where they all suffer from the same falsity in them. So this can lead to a lot of litigation about how many violations are at issue, or like what the actual violation is. As an example, in a Ninth Circuit case from 2023, where a manufacturer misrepresented that its PVC pipes were compliant with industry standards, the plaintiffs in that case argued that the violation should be considered every single individual piece of pipe that was provided that had a stamp on it, indicating compliance with those industry standards. But the Ninth Circuit held that the district court appropriately awarded there was one penalty for each of 26 projects at issue rather than for each individual piece of pipe, so that significantly narrowed down the penalties in that case. In addition to penalties for any actual damages that the government or the plaintiffs can prove, it's entitled to treble or 3 times those damages. So we have a few examples here. So say you have a contractor that bills an unallowable cost of $150,000 on a single invoice. There would be that $150,000 would be tripled for the actual damages. And then you would also have one penalty imposed for that single violation on that invoice. Alternatively, as the second example, you could have a contract where you propose a markup of 5% on a certain CLIN, but that markup somehow, whether it's inadvertent or purposeful, ends up being applied to a different CLIN instead, that leads to overpayment by the government. That could end up impacting every invoice throughout the life of the contract. So there's a difference between the fee charged and what you were entitled to, and that amount would be tripled. And then you'd also be facing the penalties on every invoice where that occurred. And then, we've touched on this a bit, but where award of the contract itself is predicated on a false statement and the contract wouldn't have been awarded but for that misrepresentation, such as the example we have here for award of a HUD zone set-aside contract that's worth $7 million in revenue, when the company is not in compliance with those requirements, the government may be able to recover the total value of the contract as its actual damages. And then that amount, that $7 million amount, would be trebled. So there are some defenses to some of the damages calculations, such as that the damages should be reduced based on the value of the goods or services that are provided, but that sees different levels of success depending on the facts of the case. And what the takeaway is that you can see that there's a potential here for very large recoveries through both damages and the penalties that government and relators can get in these cases.
If I could jump in on a couple of things really quickly. I drafted this slide and now I'm seeing that I may have made it a little ambiguous. When we talk about unallowable costs of $150,000, we're not really talking about unallowable costs and allowable costs in the cost accounting sense. What I'm referring to here is really an unallowable expense. For instance, your contract doesn't allow you to charge for travel, for instance, or specifically disclaims that you are permitted to bill for travel, and then you actually bill for travel by hiding it somewhere else in your invoice. That's sort of what we're talking about, an unallowable cost, because allowable and unallowable costs are constantly up for debate between for instance, DCMA and a contractor. And generally speaking, what's allowable and what's unallowable will not lead to a False Claims Act violation unless there's a willful attempt to misrepresent those monies. And lastly, I want to mention, with regard to this slide, when we talk about fraudulent inducement and the last example of the HUD zone set-aside contract worth $7 million, there's actually a lot of debate right now throughout the federal courts about whether You can even have a claim for fraudulent inducement. And the example we've given here, though, is the position that the Department of Justice has taken based on a Supreme Court case from several years ago. And most courts believe that a fraudulent inducement claim continues to exist under the FCA, but that may be the kind of thing that the Supreme Court has to tackle head on, and we might talk about that a little in some future slides. But again, these examples aren't an exact science, but generally speaking, the main point is the damages that get trebled are going to be tied to the type of violation that is alleged. So Jackie's giving you some examples here that fit within that model.
Okay, so last on this, background of the False Claims Act, I want to touch on the statute of limitations. These cases can have a really long shelf life due to the investigation that the government undertakes. But the statute of limitations for an FCA claim generally is 6 years from the time that the fraud was committed. So that means if a lawsuit was filed today, the relator or the government could base that lawsuit off claims submitted to the government going back 6 years. So that's a long time that you need to be able to maintain your records and have some knowledge to dig back into those claims in case there's an investigation or a lawsuit arises. But on top of that, the statute of limitations can be extended to 3 years from the time the government official charged with investigating the fraud knew or should have known about the fraud. So this rule has been interpreted in different ways, but the most common way is that the government official is considered to be DOJ officials because DOJ is the agency that files claims on behalf of the US government or would be filing the lawsuit. So it's possible that even if there's some level of knowledge within the agency where the claims are submitted to, that may be found not sufficient to trigger the statute of limitations in terms of the government having knowledge about the fraud until it comes to DOJ, and DOJ begins its investigation into the issue. But there is a statute of repose where the clock runs out at 10 years, so the government can't take action against claims that are more than 10 years old. So a very long ultimate look back period that the government has here to investigate those older claims.
All right, so converting from a little bit of the background into what we saw in 2023, it was a bit of a weird year. It was total recoveries were about $2.68 billion, which is about 20% better than fiscal year 2022 from the government's perspective, but less than 50% of 2021. 2021 was a bit of an outlier year because of a very large recovery related to the opioid epidemic. But a 20% increase over last year is I would probably characterize as middling because it's below the annual average of recoveries over the last 15 years. There was an outsized example of recoveries from TTAM initiated matters, about 2.3 billion, where the remaining approximately 300 million were from government initiated matters. And fiscal year 2023 saw a huge uptick in the overall new matters initiated, particularly on the government side. The government increased by about almost 65% the number of new matters that it filed or initiated, and that's 500 for the year. That's the highest number in history. TTAM initiated matters also went up. It's the third highest number in history at 712. So over 1,200 total new matters. What does that tell us? That means the settlements are likely to go up. The number of settlements and the amount of the settlements total amount of settlements are likely to go up in the next 3 to 5 years, because as Jackie mentioned a couple of slides ago, TTAM or False Claims Act matters have a pretty long shelf life. It takes a while for them to be investigated and resolved. And so we're likely to start seeing these numbers go up significantly over the next 3 to 5 years. Next slide, please. I've covered a little bit of this already, but one of the key takeaways, and this is something that I think Jackie and I would say we've also noticed anecdotally, the rise in new matters indicates that the government and relators are expanding their target field. what we mean by that is that they're looking for new innovative ways to bring False Claims Act matters. They're looking at further down the chain, vendors, second-tier subcontractors. They're also looking at very closely at the SBA's set-aside programs and all of the individuals who are involved in making certifications for individual companies. And they're also looking, we're going to talk about a few of these things later, obviously pandemic fraud, antitrust violations like price fixing and improper monopolies being created, and cybersecurity, all of which are going to get a little bit of attention in this webinar. So what we recommend, you've got to take subpoenas, civil investigative demands, any request for information from the government very seriously. You want to make sure that you're providing a fulsome response and explaining any problems that may arise, particularly related to money on a federal contract, so that the government is fully aware of why you're billing what you're billing and what work is being done to justify it. You also want to increase your compliance efforts. Pay attention to what your contracts and the regulations require. And then something that we've changed from years past, we used to just say take employee complaints seriously. I'm upgrading that. I think you should prioritize and investigate employee complaints, notices, and reports. And when I say employee, I mean independent contractors, vendors, customers. If they're raising these issues, they're generally doing it in good faith. It's not just to distract the company from other endeavors. And so if they believe that something is wrong and feel unheard in the process, then they're more likely to become a relator in a qui tam action down the road. Next slide. So we have some industry specific statistics that came out in the annual report from the government. Healthcare industry, it's always the largest mode of recovery. This includes things like Medicare, Medicaid, and TRICARE fraud. They aren't necessarily government contractors, but they receive money from the government to reimburse the companies for patient services, patients who have Medicare, Medicaid, or other government-funded healthcare. The total recoveries for healthcare were 1.8 billion. Pretty consistently, it's about somewhere between 60 and 70% or more each year of the total, and that's no different for 2023. There was a dip in healthcare recoveries as compared to previous years, which is interesting, but we don't expect healthcare recoveries to slow down anytime soon. Department of Defense saw a significant increase in total recoveries at 552 million. That is more than 5 times the recoveries from fiscal year 2022 and the largest recovery amount since fiscal year 2006. Essentially what that means is that the government is focusing very heavily on procurement fraud and products and services provided to the military. We can go to the next slide. Couple of key takeaways from this: companies in healthcare industry, and that isn't just companies that are accepting money through Medicare, Medicaid, but government contractors that work in healthcare that provide doctors, nurses, or other healthcare providers for the VA or for HHS. Be very vigilant about the bills that you're sending to the government. If you do work with Medicare or Medicaid, make sure that you're complying with the applicable regulations, which are constantly updated and often without appropriate guidance or necessary guidance from HHS. And companies operating in defense must be cognizant of the increased scrutiny by DOJ and the Office of Inspector General. Defense has not always been a heavy focus for DOJ in the False Claims Act area, but there are some major cases on product problems like earplugs and bulletproof vests that have been alleged to be deficient products, and those have steered additional scrutiny toward Department of Defense. Again, we recommend implementing compliance programs and audit procedures to ensure that the company is cognizant of obligations of its contracts and making sure that it's up to date on industry standards for any products or services it's providing to the government. here again is important, and a little important tidbit. You want to make sure that you're compliant with your cybersecurity requirements. Those of you who are government contractors may know about CMMC. Over the last 5 years or so, there's been a shift in the cybersecurity requirements, although there's been some flexibility. The government has not imposed certain requirements on all contracts so far, or at least in the past. Now you're walking into a new cybersecurity world, and you're going to need to make sure that you're compliant with those cybersecurity obligations, whether they are a mandatory certification that you're making on an invoice, or like Jackie described before, a requirement of your contract that you don't have to specifically certify in an invoice. It could be an implied certification. All right, next slide. The last thing I'm going to talk about, then I'm going to hand it back to Jackie, is COVID-related fraud. Since the start of the pandemic, DOJ has worked with IGs and various agencies to weed out pandemic-related fraud. Not only does that include fraud related to bailout money like PPP loans, EIDL loans, shuttered venue operators grant, or restaurant revitalization fund payments, but it also relates to companies and individuals who are defrauding the government or the American people based on the heightened fears arising out of the pandemic. For instance, companies that may have misrepresented that their masks that they were selling or other personal protective equipment was able to protect individuals from COVID when it was not, or they were of low quality. In particular, qui tam plaintiffs and the government are scrutinizing how grant and bailout funds are being spent and whether companies were eligible or used the funds for eligible purposes. The Department of Justice has created an entire task force related to pandemic fraud, and so there is a lot of attention on pandemic-related issues arising out of the FCA. With regard to our recommendations, you want to make sure that you have a paper trail to ensure all of your federal dollars from pandemic-related programs were spent for reasons they were distributed, and conforming to the updated rules that were implemented by the SBA and the Treasury to ensure that PPP loans were given to the appropriate companies and that the funds were ultimately used for proper purposes.
Okay, moving on to procurement fraud. DOJ doesn't publish annual statistics on procurement fraud matters and recoveries, so we don't have statistics on that, but they provide some examples in this area, and we see that there's a continuing trend of settlements covering various types of alleged fraudulent conduct in this area, showing that DOJ's focus here definitely remains strong. So we've listed some of the types of recent settlements that we've seen that are based on procurement fraud. Improper billing is a big one, and in fact, DOJ announced one of the largest settlements in procurement fraud history. And this is interesting, it relates back to Matt was talking about it being, not that frequent that FCA settlements or lawsuits are based on the federal cost accounting standards and what costs are allowable or unallowable. But here this involved a contractor paying $377 million to resolve allegations that it improperly billed indirect costs to the government. The allegations were that the contractor improperly allocated to government contracts indirect costs that were associated with its non-governmental commercial and international contracts that either had no relationship to the government contracts or were allocated to those contracts in disproportionate amounts. So it didn't meet the requirements of being reasonably related to the government contracts. So the result was that the contractor allegedly obtained reimbursement from the US for costs of non-governmental activities that provided no benefit to the US. So this is one of those relatively rare examples of an FCA settlement that deals with alleged violations of the cost accounting standards. So we also have, sorry, we're sticking with the procurement fraud slide. Another type of settlement is where the contractor provides products or services that don't comply with contract requirements. Matt was talking about this, often deals with DoD procurements because it's so important to have products that are up to par and meet all specifications there. So for instance, DOJ announced that a contractor agreed to pay around $8 million to resolve allegations that it submitted false claims by failing to comply with manufacturing specifications for fabricating components of military aircraft under its contract and failing to perform monthly testing as required, which could impact the safety of the military aircraft. There's also been settlements based on allegations of non-compliance with statutory or regulatory requirements, such as domestic sourcing requirements that might be included in the contract based on Buy American Act or the Trade Agreements Act, and various other domestic sourcing requirements. So there have been allegations, for instance, where or settlements where a company agreed to comply with those domestic sourcing requirements and said that its products were made in the USA when actually they're manufactured in eligible foreign countries. There's been a lot of money is pouring into infrastructure in this country, and there have been a lot of changes as well to the federal domestic sourcing regulations. So I would anticipate even more focus here on compliance with domestic sourcing requirements in federal procurements. And then let's see, another big area is small business misrepresentations that can lead to FCA liability. And this can occur in a number of different ways. We've talked about fraudulent inducement in getting the contracts in the first place through misrepresentation, whether a small business improperly represents that it's small, perhaps if it has affiliates under SBA's regulations, but it fails to account for the affiliate's revenues when it's calculating its size, or if it loses its status after a merger or acquisition, and then doesn't, update that it's no longer a small business. That really will impact the contract depending on whether there are recertification requirements or whether you're bidding on a new contract. But there can also be situations where the small company is not owned and controlled by the proper individual, for instance, by a woman for a woman-owned small business. And then there's also the issue of allegations related to contract performance rather than initial eligibility, where there are self-performance requirements like limitations on subcontracting, or in a joint venture that the small business joint venture, the protege, perform a certain percentage of the work rather than the large business. DOJ will investigate those situations where it looks like the small business is not meeting those requirements and it is, as I mentioned earlier, kind of functioning as a sham company and passing work through to a large business who shouldn't be performing that work. So it's super important to avoid these situations, to stay abreast of eligibility requirements, methods for calculating size. These regulations and requirements change over time, as well as tracking performance by the small business and by teaming partners if they're not similarly situated small businesses.
So before we move on, we've got a couple of good questions from the audience. First, there's a question about what are the ramifications or repercussions for the contracting officer or COR, contracting officer's representative, when there are FCA violations? And the reality is not much. Generally, a CO or COR, unless we're talking about receiving a bribe, the CO or COR is not going to be liable under the FCA. However, a CO or COR's knowledge of a potential FCA violation in an invoice, let's say that a contractor is invoicing for 7 full-time employees on a contract when it's only permitted to invoice for 6, but that one would call that fraud in plain sight. There are 7 FTEs on the invoice. Maybe it's because the contracting officer asked to increase the staffing but never executed a mod or modification to increase the funding on the contract or to approve the 7th FTE. In those instances, the contractor has a defense to a potential FCA violation called the government knowledge defense, It can also be evidence that the alleged misrepresentation wasn't material to the government's decision to pay the claim. So understanding what the contract, or getting a handle on what the contracting officer or COR knows related to a potential FCA violation, communicating with the CO and COR in writing in order for there to be a paper trail, all of that is very important. But the short answer to the question is that realistically, government employees are not going to often be found liable under the FCA. They may be terminated, they may be suspended through an internal personnel action, but typically there's not going to be any FCA liability. Separately, we had a question about, for particularly small businesses, are there more PFCRA, which is procurement, if I recall correctly, Procurement Fraud Civil Remedies Act versus FCA claims. So the PFCRA applies to claims under $150,000. And there are cases where the government has, usually the Department of Justice, has declined to proceed with an action under the False Claims Act. So we're talking about very, very small claims. The vast majority of FCA matters, even for small businesses, are going to be full-blown FCA claims, because $150,000, when you triple it, we're talking about a $50,000 claim. It is certainly possible, but the vast majority of FCA claims that the government spends its time and money on are going to be much larger FCA claims rather than PFCRA claims. Okay, we can go to the next slide.
Okay, yeah, so I wanted to touch on the Civil Cyber Fraud Initiative. This was started back in 2021 when DOJ announced the initiative to pursue misrepresentations by companies in connection with the government's acquisition of IT software, cloud-based storage, and related services designed to protect highly sensitive government information from cybersecurity threats and compromises. The purpose of the initiative is not to create new cybersecurity requirements on its own, but to better enforce those requirements that already exist and to deter non-compliance with those requirements. So, to that effect, liability under the FCA wouldn't stem from a cyber breach in the first place necessarily, but rather when the company misrepresents its compliance with the security program, whether its program is compliant with all requirements or not, and if it is not compliant with its reporting obligations. So in March of 2022, DOJ announced the first settlement under the initiative, and we've seen a couple more settlements in FY23. For instance, a contractor settled for $4 million, allegations that it failed to satisfy cybersecurity controls in connection with a contract to provide IT services to federal agencies. This settlement's notable because the contractor actually self-disclosed the violation, and it received cooperation credit from DOJ for its cooperation of the investigation and its self-disclosure, which decreased the settlement amount that it had to pay. And then going back to the healthcare context, another contractor paid $290,000 to settle allegations that it failed to secure personal information on federally funded health insurance websites hosted and maintained by the contractor. So it's not surprising that a lot of attention here goes to the healthcare industry due to the various requirements for protecting patient privacy. But cyber FCA risks are also growing for all contractors that are subject to the increasing cybersecurity requirements. Matt already mentioned CMMC requirements, and there are also a lot of new and evolving demanding requirements from agencies for providing quick notices of cybersecurity breaches. So failing to comply with those fast turnaround notice requirements where there is a breach could also lead to a basis for FCA liability. So it's super important to stay up to date on these changing and evolving cybersecurity requirements that are included in your contracts. Next, I wanted to touch on some other fraud recoveries that was DOJ has mentioned over the past year. They show that there's a diversity of FCA enforcement efforts across many programs and schemes that DOJ is seeing. For instance, there is a $40 million settlement to resolve allegations that a contractor inflated its prices and violated FCC's competitive bidding regulations in connection with the contractor's participation in this FCC program. So that relates to anti-competitive conduct as an area that DOJ is focused on. There's also a settlement where a contractor misclassified its products under the harmonized tariff schedule as related to paying customs. So it tried to decrease the amount of customs duties that it would have to pay. So that's a different area, looking into customs requirements where FCA liability can fall. And this third example that we have here is there's a settlement to resolve allegations that a university and a professor at the university failed to disclose certain patents and share patent royalties with the government for inventions that were made by the professor when he worked both for VA and for the university. So that just shows, that DOJ is really investigating a lot of different areas, and the False Claims Act is incredibly broad. All right, so let's move on from there.
Yeah, so the sort of details about the FCA aren't just related to numbers and new matters for 2023. The FCA went to the Supreme Court of the United States twice in 2023. There are also some legislative matters that were proceeding through Congress. First at the FCA, next slide, please. We have the Schutt decision. This was received a lot of attention when it came out, and will continue to receive a lot of attention over the next, well, probably forever. In that case, I'm going to skip through the facts a little bit, but it's a healthcare fraud case where pharmacies were allegedly misrepresenting their usual and customary price, which impacts the amount that the federal government ends up reimbursing these pharmacies. Ultimately, the Supreme Court decided that the intent requirement under the FCA requires the court and the jury to consider this, the defendant's subjective beliefs and knowledge, not just what an objectively reasonable person may have known or believed, but what we actually see in the conversations or on the documents that the defendant had at the time of the alleged FCA violation. This was largely seen as a win for plaintiffs, for relators, because it allows companies that intended to violate the FCA but maybe could have gotten away with it because there was a confusing or poorly worded regulation or statute. Now it really turns on whether they subjectively believed in the truth of the information they were providing to the government or to providing to the agency in order to get paid. The court also defined, next slide, the reckless disregard and deliberate ignorance standards that are so prevalent in FCA litigation now. And reckless disregard was officially described as circumstances where the defendant is conscious of a substantial and unjustifiable risk that their claims are false, but submits the claim anyway. And deliberate ignorance is that a defendant is aware of a substantial risk that their statements are false, but it intentionally avoids taking steps to confirm the statement's truth or validity. We sometimes refer to the deliberate ignorance standard as the ostrich principle, where the decision maker sticks their head in the sand and casually ignores all of the fraud going on around them. But they try to maintain plausible deniability. Those decisions, the Schutt decision, will give us some background for future FCA litigation moving forward. The second one, although perhaps not quite as important, is the Polanski decision. In that case, there is a very long road, one of FCA litigation, multi-years and many millions of dollars in costs incurred by the plaintiff and the defendant on this FCA case. And as we get closer to the time of trial, the government finally says, you all are spending too much money and you're making the government do too much work to give you documents. The government had not intervened in that case, but the government filed a motion to dismiss and said, we want this case to go away because it's now become disadvantageous for the government to even be involved. And the court did dismiss the case, and ultimately it got to the Supreme Court, where the court said, basically the government has very wide discretion once it intervenes in litigation, which it can do at any time, to dismiss False Claims Act matters that they don't find favorable. Polanski was more important, however, for a dissent or concurrence, actually, that Justice Thomas wrote, where he called into question whether it was even constitutional for there to be a qui tam action where the government declines to intervene. There have been a number of district court cases filed since then and that have been proceeding in the normal course that challenge the constitutionality of the qui tam process. And we expect that question to get to the Supreme Court sometime, probably in the next 3 or 4 years. And the court will have to determine whether qui tam relators are even permitted to advance suits on behalf of the government. Next slide.
Okay, I want to touch on a couple legislative updates that are under consideration with Congress. So first, we have the False Claims Amendments Act of 2023. Senator Grassley is behind both of these. He's led the way with efforts to strengthen the FCA for decades, and so he's continuing that here. So this first act would expand whistleblower protections to former employees, as well as currently they're provided for current employees. And it would also address an issue that has been raised by a Supreme Court case in Escobar from a few years ago. Escobar indicated that the materiality standard is demanding, and that continuing payments by the government when it has knowledge of FCA violations is strong evidence that those violations are not material to the government's decision to pay the claim. And some people see that as creating a loophole to avoid FCA liability by pointing to the government's continued payment despite their violations, when there might be various reasons for keeping the contract in place and continuing payment. So this act would clarify that continued payments from the government do not negate FCA liability, would try to weaken that materiality. And then there's also the Administrative False Claims Act. But Matt spoke to this earlier, but it targets small but more frequent instances of fraud against the government, and it would raise the current ceiling for handling these sorts of claims administratively rather than in court from 150,000 to 1 million. So it can move dealing with some sorts of false claims through this administrative process rather than in court. And it would also allow the government to be able to recover costs for investigations and expenses of prosecution. This latter one has bipartisan support, and it passed the Senate, but it's been sitting in the House since April of 2023. The first act is still at the Judiciary Committee in the Senate. So, it remains to be seen whether we see any changes here, as there's generally legislation related to FCA each year. So moving on from there, some FCA trends. We've touched on most of these. So we're seeing record numbers of settlements and judgments. There's still this primary focus on the healthcare industry. That's likely not going to change, but we've seen one of the largest procurement fraud settlements. Procurement fraud remains a primary focus as well of the government and continues to increase, though not nearly to the same level as the healthcare industry settlements. As Matt touched on, we may see more FCA action at the Supreme Court over the years, particularly with this qui tam and other circuit splits that may come up on different areas of FCA issues. And then we're seeing increasing DOJ focus, we've talked throughout the presentation, related to cyber fraud, COVID-19 fraud, as there have been these changing requirements, as well as this focus on anti-competitive conduct and procurement collusion with the creation of the Procurement Collusion Strike Force from 2019, which still remains active. I'm wanting to speed along here. Okay, so moving on to how you can protect yourself from FCA liability. You need to ensure regulatory and contract compliance. That means that you need to know what the law and your contracts require. You need to actually read them. I know it can be hundreds of pages long, but you have to actually look at what those requirements are, both in the statement of work and what the standards are for your products and services, as well as understanding what the FAR clauses that are incorporated into your contract, what those require and what those mean. You should have standard operating procedures within the company so that you know who's handling invoices and how you're going to maintain contract compliance. Creating checklists to make sure that you are complying with those requirements and meeting your obligations. By assigning duties to specific employees, that ensures that you have someone dedicated to handling the various issues, whether that's invoicing or checking to make sure that the contract is being complied with. And assigning multiple people across these requirements helps to ensure that you have checks and balances, so you're not just relying on a single person who might slip up and cause major problems for the company. You also need to make sure that you're doing training for employees who can understand the requirements of the contract and what their obligations are at the company, and training managers as well, so they can help guide the lower level employees to comply with their requirements. And it's super important to maintain and take contemporaneous documentation of your understanding of ambiguous requirements in the contract, and making efforts to understand those requirements and discuss them with the agency so that you can show what your good faith interpretation of those requirements are. As Matt talked on about this point earlier, but it's super important to take complaints seriously to avoid key TAM suits. You need to investigate all those complaints that come in and document what you're doing for those investigations. And then you also need to create a contingency plan ahead of time so that if an FCA issue arises, you already have a plan in place about what you're going to do to deal with it. For instance, who are you going to hire to assist? Who are you going to speak to when an issue pops up? You need to make sure that you're aware of the potential for needing to make a mandatory disclosure. That's a requirement for federal contractors under their contracts where they have credible evidence of a FCA violation. They need to disclose that to the government, and failing to do so can lead to suspension or debarment if they fail to timely disclose credible evidence of those violations. And that's also important because that self-disclosure, as I've mentioned throughout the presentation, can lead to cooperation credit from DOJ. So you may face lower damages or penalties if you work with DOJ in their investigation, and if you self-disclose when you have evidence of those violations.
So what should you do if faced with an FCA matter? And for those of you who have things scheduled for 3 o'clock, we're going to be done in just a couple of minutes. First of all, you're probably going to find out about it through a vague notice. You might get a grand jury subpoena, a civil investigative demand, a civil subpoena from an Office of Inspector General. Those things may vaguely reference an FCA, and then they might ask for all documents related to a contract. You might not have any idea what they're talking about, may not have any clue that there's an allegation of fraud against you, but typically that the receipt of the subpoena, the civil investigative demand, is going to clue you in that something's going on. But of course, you might just be a witness. But anytime you receive it, it's important to think about what your next steps will be. The bigger deal when you know something is really going on is when they show up at your office with a search warrant. I have had instances before where clients had a team of FBI agents wearing flak jackets and carrying machine guns showed up to try and take computers. The important thing to know is you've got to implement that contingency plan. Who am I calling when this type of thing occurs? And keep in mind, it's rare for a search warrant to be executed in a civil matter. But who am I calling? What am I doing? Am I letting my employees talk to investigators? Am I talking to the investigator? And the reality is, don't talk to the government without talking to your counsel first. Ideally, you want your counsel to be the one who's speaking to the government. You may be 100% happy cooperating with the government, and frequently that's the advice we would give a client. But you want to make sure that you've run things by the lawyer before doing so, because the Department of Justice, the FBI, they've done this before. They know what questions to ask, and they know how to twist people's words to get the answer that they're looking for. Overall, don't panic, just implement that contingency plan and you'll be in good hands. If you are served with a search warrant and someone shows up on your front door, ask to see it, make sure it's signed, and then refer them to your counsel. If you have investigators who show up and want to interview you, defer the interview until you've had counsel involved. Next slides. These are some preliminary things you have to do. Stop any routine document email destruction or archiving. If you end up shredding documents 3 days after the FBI dropped a CID on your doorstep, it's going to look bad for you, and it may not be intentional. So you want to make sure that you're preserving documents as soon as you have noticed that there may be an investigation related to the FCA. Obviously, you want to get knowledgeable counsel to act on your behalf. It is easy to make mistakes when talking to the government, particularly when you have no idea what they're investigating. And so it's important to have a lawyer there so that your communications with your lawyer are privileged and the lawyer can get as much information from the government as possible. You will want to engage in an internal investigation in the event that you or someone at your company receives a CID related to a purported False Claims Act violation. Ideally, you want that to be conducted by an attorney so that the attorney-client privilege extends to it. And you want to identify knowledgeable witnesses and be forthcoming with your attorney to identify those people so that they can be interviewed. Verify your paper trail. That means make sure you're collecting all of the documents that might be relevant and turning them over to your attorney so that your attorney can conduct the investigation. And document what you're going on. If you're talking to an employee and they say, yeah, I was interviewed by the FBI, you want to start taking notes, understand what was asked, understand what they said, know what you are getting yourself into before things get too far ahead. We have come to the end of this year's presentation. There are a few questions that are in our inbox, but we're about 8 minutes over. If you still have questions, feel free to reach out to me or to Jackie. Our email addresses and phone numbers are up on the screen now. We'll see you next year for next year's annual review. Hopefully we'll be able to give you some additional insights, but always feel free to reach out to us if you have questions in between. Thanks a lot, and we hope to hear from you soon.
Thanks, everybody. Thanks, Matt.